Well, hello there, folks. This is Bill O'Leary here in this video. And the topic I'm going to talk about here is the question, should I buy my parents' home if they're in a nursing home? So what I'm going to do is teach you three things in this video. Number one, whether someone going on Medicaid can keep the home, number one. Number two, what happens to Medicaid eligibility if the home is sold? And number three, whether there are any planning options for selling the home and staying on Medicaid. So again, my name is Bill O'Leary. I'm an attorney that I focus on estate planning, elder law, and probate. And my law firm is Legacy Planning Law Group, and we are in Jacksonville, Florida. So let's get started. Look, if your loved one is in a nursing home and they're wanting to go on Medicaid in Florida, the question is, can they get on Medicaid if they own a home? Well, the answer is yes. Yes. As long as they used to live in the home, they can still get on Medicaid. They can keep the home. Why? Because Medicaid considers it to be their homestead. Your parent would just need to show that they intend to return to the home after going into the nursing home. Now, everyone involved, including the folks at Medicaid, know full well that once you go to a nursing home, that you're really not going to be going back home. But it is really easy to simply say, hey, you have an intent to return. You just say that on the application, and Medicaid accepts that at face value. And so by doing that, Medicaid is not going to count the home against your elderly loved one in sort of computing the assets that person is allowed to keep. Medicaid is not going to count it. Well, that's all well and good. So somebody going on Medicaid can keep the home. Well, here's what often happens in the real world. The family is stuck with keeping up the house and paying the taxes, the utilities, insurance, maintenance cost, upkeep, and the like. So what happens now if the family doesn't want to maintain the house anymore? It gets expensive. Well, renting out the house may not solve the problem because the net rental income is going to have to go to the nursing home as part of the patient responsibility, the patient share of the cost. So that really doesn't help much, doesn't advance the ball. Well, what if instead of renting the house, the family decides to sell it? What happens in that situation? Well, what they've done is they've converted an asset from one that is considered exempt by Medicaid, not counted, the homestead, converted it to an asset that is countable, cash. Once the home is sold and the proceeds then come in, the Medicaid recipient has to disclose the sale to Medicaid within 10 days, because that is a substantial change in circumstance. So you've got to let them know in 10 days. And so then the sale proceeds will take that Medicaid recipient off of Medicaid, but only if they keep the funds from the sale. Medicaid, understand, will not take the money away from the sale. They will not take it away. But instead, what they will do is sort of kick that Medicaid beneficiary off of the Medicaid rolls unless the family acts quickly. So in order for that person to be able to stay on Medicaid, the sale proceeds must be legally spent or legally protected by the end of the following month. So before the house is sold, you're going to want to plan ahead, work with an elder law attorney like us at Legacy Planning Law Group, but an elder law attorney nonetheless. And there are a number of planning options that may be available to protect the sale proceeds. And these planning options may include things like a Medicaid spend down plan, or maybe paying off creditors or family members for loans that were made, maybe what's called a personal service contract with a family member who's a caregiver, maybe buying income producing real estate, maybe something called a pooled trust. And I don't have time to go into each of these planning options in this video. In fact, each could be a separate video unto itself. Just know there are legal planning tools that can be used to protect the house sale proceeds. I want to real quick talk about a couple of other planning options. One does not involve selling the house. So what you could do instead, you don't want to be maintaining the house anymore, have your ailing parent execute a special kind of deed called a ladybird deed, which will transfer the house to, let's say, you as the child automatically at their death. It'll be outside of the probate court, and it will also be beyond the reach of Medicaid taking the house after death in a process called Medicaid estate recovery. So this Lady Bird deed avoids both of those, the probate and the Medicaid estate recovery after your parents' death. Then, once executing that deed, your parent, or maybe you holding a power of attorney on your parents' behalf, can rent out the home while your parent is still alive for the rest of their lifetime. And although it is true that the net rental income will have to go to the facility as part of the patient responsibility, at least what you will have done with this strategy is preserved the house as an asset to inherit after your parent dies. So that's one planning option that would not involve selling the house. Real quick, another planning option that actually does involve selling the house, but then investing the sale proceeds into a new home that, let's say, you as a child would own with your parent. Okay, so a home is bought, and let's say it's a 50-50 ownership. Your parent puts in 50% of the money and it's owned jointly with you. If your parent later needs to go on Medicaid, the half ownership that they have in the home will not be counted against them because it's considered their homestead. Even though it's only a 50% ownership interest, it still qualifies for the homestead. Although understand that any amount that your parent invests in the new home cannot exceed an equity cap that Medicaid imposes here in Florida. In the year 2023, that is $688,000. So if it's not a really expensive house, it should be fine. You then, after this is done, your parent invests 50%, and let's say then they might even go into a nursing home at that point. You are paying the cost of upkeep. You're responsible for the mortgage payments, the homeowner's insurance, property taxes, etc., and upkeep on the home. And then upon your parents' death, the interest in the home, their 50%, will pass to you directly outside of the probate court because you owned it with right of survivorship. And so this way, your parents' ownership interest in the home, again, not only will go to you directly outside of probate, but will also avoid that Medicaid estate recovery process that we talked about, okay? Because it goes straight away to you as joint with right of survivorship. Medicaid can't come take it. So if you'd like to know a little bit more about whether you should buy your parents' home, if they're in a nursing home, and maybe how we can help you, we'd love to talk to you. So go ahead and take that first easy step by scheduling a free 15-minute phone call with us. We call it our discovery call. Just go to the link at the bottom of this video, click on it, and pick the day and time that works for you best, and we will get on the call with you at that time. If you've enjoyed this video, would ask you to like it and share it and comment. And also, if you haven't done already, do subscribe to our YouTube channel here, Legacy Planning Law Group. So Bill O'Leary signing off for now on behalf of everybody here at my firm. We call ourselves Team Legacy. Go make it a great day and a better world.